Hi, everybody. Good afternoon. You probably already heard about P.Diddy. He was only found guilty on two counts, two charges, 3 and 5. So they each carry a maximum of 10 years. They could be, he could face a maximum of 20 years, but the attitude outside the courtroom and everything, people are thinking that P. Diddy's walking today. They're trying to get him out on bail. The defense is. The prosecution doesn't want that. We'll see what happens. The judge is going to be there the entire day, and so we'll see. But he only was found guilty on the prostitution, the transportation counts, nothing else. Everything else was not guilty. So it is a big victory for him and his supporters. You know what they say, money talks, like what I told you yesterday, and Diddy walks. Will he walk on time served? I don't know. I think he should at the very least, have 5 years, right? You would think. Anybody else would not be even in this position. But again, money talks, Diddy walks. So, but right now we're going to talk about Kohberger, and we're going to wait for this to start. This is his change of plea hearing. So that's what we're here for. I'm just trying to share this out because I had to do something before this, and of course, I've also put an update on our GoFundMe for our legal funds, and I've also copied that update on the community post. So if you want to take a look at that, you're able to take a look at that. If you're able to donate, we appreciate that very much. If you're able to share it out, we appreciate that very much, and we're always thankful and grateful for your prayers. Those are most importantly. Now, let me just go and finish sharing this out. Don't worry, that background noise is not going to be on when this is on. Luke's just getting his water bottle filled up. Okay. Got that there. I just need to share it out one other place. And I have to fix the link to the GoFundMe. I have the wrong link there. I'll do that right now. Okay, let me put the correct link on the other thing. Oops. Okay, let me go fix this. You'll still be able to read the update on the community page, but I just want to make sure that I have the right link in there if you'd like to share it, because that's very appreciated. There we go. Perfect. Okay, so we wait for court here to start. Hi, Murder of Crows. Hi, Rochelle. Hi, Gianna Marie. Good to see you. I'm seeing so many people I haven't seen, and so every single live stream, there's more people that I haven't seen in ages. And in the comments, it's crazy. I think our algorithms are finally changing. I don't know. People are telling me they're not getting notifications on certain things, but I think we're coming up on certain other things. Hi, Christine. Hope you're all doing well. You all heard about Diddy. Christine, did you hear about Diddy? There's quite a crowd at the Lower Manhattan Federal Courthouse. We're waiting here for the Ada County Court to get in session. They said at 1 p.m. It is 1:01 p.m. But Diddy was only found guilty on 2 counts, counts 3 and count 5. And that are the prostitute. Hold on one second. Wait. Be good. Be careful. Love you. Good luck. Michelle says, good to see you. I'm on social media on and off. Yeah, that's crazy about Diddy. Yeah. Yep. Yeah. I'm sure there's a lot of people that are nervous or whatever, but, you know, really, if there's ever a case, right, about money talking, right? Diddy walking. Though I don't see how he can walk. I really don't. But, you know, I think, is he going to get bail until sentencing? You know, anybody else would be, you know, he's facing a maximum of 20 years. Okay? If they run it consecutively, the 2 counts. They have a maximum of 10 years. He served what, 8 months? Don't you think you're facing a maximum of 20, that it would be at least 5 years, right? Like that would be the least. I don't know. But yeah, I mean, again, money talks. And what did Gianna say? Guilty? Yeah. Okay, I'm going to get I made my coffee ages ago. Then I did the GoFundMe update. Then I did, and it's just like my coffee is cold. It's always cold. Always.
It's in the coffee machine.
I know. Always cold.
You got the dome, man. I don't think there's.
Yeah, my coffee is iced coffee. Make sure you have everything you need, Luke.
I don't know. I don't know
All your ID and everything.
I don't have. I only have one.
Well,
ID.
your permit and everything.
Yeah.
Okay. It's a nice day. It turned out to be a sunny, nice day. And I think after this I'll go for a swim. I think so. I will. Hold on a moment. I'll be right there. I'm not gonna let that, I don't wanna let that, okay. And I will cut all the background noise, when this starts. I will cut it all out. So I wonder how many of the family members got there. I wonder if there's any kind of an issue in the courtroom that they're delayed. Does anybody know? Who knows, right? And murder crows, you don't know. You don't know. Like Tico said, I forget what name he uses now, Prime Objective. There's 2 tiers of justice, right? He's definitely on the top tier there. So we'll see. Believe me, if you or I or somebody was up there with that, found guilty of those 2 charges, we'd be doing some time in a federal prison. They act like it's nothing, right? Oh, it's just prostitution charges. What about all the drugs? I mean, I don't even understand that. It's baffling, baffling. Money talks. It sure does, Gianna. We'll be doing at least 20, yeah. 20 and then some extra stuff tacked on there. Right, Murder Crows? You get away with pretty much anything. It's crazy. If he's let go, he may flee. He has lots of connections. Yeah, I know, but they'd find. They said that, but how could they not find? Yeah, it's okay, Linda. So the court's like 10 minutes late. I wonder if there's anything going on in the courtroom. Perhaps they're waiting for a family member to get there. I don't know. Hey there. I don't know why we're still playing Christmas music. I didn't even know that, but thank you so much, Murder of Crows. That is so appreciated. Thank you. Unbelievable. Thank you. Appreciate that very much. me just take a little Pikachu. I always get nervous when the court is late and that we're not. I want to make sure that, yeah, Idaho, here we are. Yeah, that we're on the right stream. I just get nervous. I'm a checker. Okay, we're on the right stream. It's late. Why has the sub have changed? Why has the sub have changed? Let me see. What do you mean? Hold on one second. I have to go to my dashboard. I don't know what you mean. The subs are almost ready to hit the next level. We're ready to level up. They've grown. I don't know what you mean changed. I'm looking right now. Oh, I know what you're saying. It goes to members only. But we're not in members only. Are you? Oh, I think. Are you looking at that top fans? That's something that they put there. That YouTube put that there for some reason. To encourage interaction. See how it says like Rochelle is number 1, Linda's number 2. But I don't even understand how it works because you and Murder Crows have been talking a lot. And it doesn't even have a number for you guys. It changed when you tried to resub? What do you mean? The chat should be subscribers only, Gianna. It's always been that way. I'm kind of lost. I'm not understanding. It doesn't like you. YouTube doesn't like you. I don't know why. I really don't understand that whole thing. I don't. Hi, Lady Elaine. Why is the chat on subscribers only? Well, it doesn't cost to be a subscriber, Gianna, and it keeps trolls out usually. Though they create profiles and subscribe, so but a lot of creators do it. We've been doing it for years. You're not subbed? Why not?
General Stephen Hippler, presiding judge.
All right.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well,
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000, and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, You did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 11.
I'm hearing an echo, but it's not on my side that I can see.
Starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door.
I think they fixed it. It wasn't on our side.
Side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single-source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single-source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you, Your Honor.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly, both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right,
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned.
All right, please.
Okay, so hold on a minute. Stop that. they didn't, they're keeping the gag order because they don't want, I guess, a bunch of bombardment with media interviews and whatnot. And they didn't mention the discovery. Now, just in the, people say, oh, I want to see it. With Chris Watts' case, after the sentencing, they released all the discovery. And that included all the telephone interviews with that friend of his or her friends, and all the police cam, all the interviews, interrogations. I don't know what they're planning to do in this case, but I think they should at least do that because so many people want to see that are family members of the victims, but hopefully they will not keep that under seal. We'll see, I guess. The 23rd, is that correct? I heard that correctly, into the 24th. I would imagine there are going to be so many people speaking that they are going to need those 2 days. 4 different families with, I'm sure, at least maybe 4 people speaking from each family at least. I know with, what's her name? The one with the golf, that ran into the golf cart, Jamie Komorowski. There were a lot of people that spoke there, and that was just, that wasn't the scope of victims here. There are just 4 victims and their families, so I don't know how it couldn't go into 2 days. His jail calls, yeah, we'll see what we can do. But there's I'm a little bit split because on the one hand, I think I would need to hear him say he's guilty, as he did here. I think to go through a trial, like say Murdaugh, right? Have him say, you've got the wrong guy, I didn't do this, have them continue to say they didn't do this. That's the reason I would do the plea, because he is admitting, it's read off to him what he did, and he's saying, I'm guilty, I did it. That means, to me, just hearing him say this as a layperson, that means a lot. Because to have your family member brutally murdered and then have the person going around saying they didn't do this, they didn't do this, they didn't do this, I don't know, I feel is worse. I feel like, okay, I don't know. Do you know what I mean? I don't know if I'm... To have him come right out and say that. And I was waiting, I'm telling you. It was making me very nervous in the gallery there. Every time certain names would be mentioned or something, there would be this one guy that was looking around as if, I really thought someone was going to come jumping over the little barricade there. I don't know. It must be so unnerving to sit there with someone that murdered your child, just sitting there like that, so stoic and just matter-of-factly saying that I know everyone always wants to hear why, but I don't think they'll ever answer. Even if they give you an answer, it's like that judge said in Murdaugh's case, you have the chance now to do what everyone convicted like should, but you'll never do it. I've never seen one convicted murderer do it. You know, confess and say factually why, how. No. They may give you a story. I don't think it's ever going to be the complete truth. Yeah, you get it, right? But he is saying he did this. And at least at the end of the day, they have that. And while they, and I think it was good that the prosecutor went over all of the evidence that they had. But let's just say, I don't know, they tried the case and he got off. So at this point, they know he admitted it. He's going to be put away for the rest of his life. No parole. And, you know, whatever, it was a split decision. So either way, there's two families that are, I'm not going to say happy, that are content with the plea deal, and two families that are furious about the plea deal. How do you reconcile that? How can you change, that so that four families are content? I don't think there's a way to do it because of just how it is, right? So at least they'll all get to speak. I really do want to hear the victims' impact statements and have their say. Even though they're supposed to be addressing the court, we saw in Monica Simontelli, though the judge said that, he clearly let each of those victims have their full say and directed it at Monica. So we shall see. And then Diddy is another thing, right? So what is going to go on with Diddy? Like, can I just take a look to see if they decided anything about the bail or bond? Let me see. Let me just check that out before we go. It's a beautiful sunny day. Let me just see if they have any update on that. All right, let's see. And if you just haven't heard anything about Diddy, just about an hour of deliberation today, the jury, which couldn't get it together on count one yesterday, had a verdict on all 5 counts. And they only found him guilty on count 3 and 5, which are the lesser charges. They each carry a maximum of 10 years, which potentially, if they were run consecutively, could mean 20 years. But again, this is P. Diddy. We're seeing that money talks, Diddy walks. People are talking about him getting time served, when you'd say at the very minimum he should do 5 years in a federal prison with that, being convicted of just those 2 charges. But who knows at this point, truly. So let's see what's going on with possible sentencing. Prosecutors say they would seek a prison term. The maximum for the prosecution-related charges is 10. For the prostitution-related charges is 10 years each. After hearing the verdict, Sean Combs held his hands up in a prayer motion. He looked at the jury and he hugged his defense lawyer, Tini Garagos. He later continued to pump his right fist subtly. He seemed satisfied that he was acquitted on the most serious charges. He appeared overwhelmed. He wiped his face. He turned. He was kneeling at his chair, and his head was bowed in prayer, according to those in the courtroom. The defense lawyers argued that Diddy should be released on bond. Hold on one second. I just want to get... let me just put this up here so we know that we're talking about Diddy. Just in case anybody thinks we're talking about Kohberger. I don't think so, but let's just try to make it clear here. There we go. All right, let's go back. So defense is arguing that he should be out on bond, that it's just prostitution charges. And the judge had asked the prosecutor for the man charges, that's what they're called. You know, what's the protocol in previous cases? And so the defense was arguing against the prosecutor's assertion that Sean Combs is a flight risk or a danger to the community. And they said that Sean has missed some big moments in the lives of his children while he's been behind bars since his arrest in September. They say he has missed the high school graduation of his twin daughters, who didn't have a parent with them because their mother, Kim Porter, died in 2018. And they said he's been separated from his 2-year-old daughter and needs and wants to be with and remain with his family. Okay, and this is this today? Yeah, okay, so here's something. Let me just see if I pull this up here. This is a filing by the prosecution. And it says, Dear Judge Submarinian, Mr. Combs moves for release or appropriate conditions pursuant to 18 U.S.C. 3143A1 pending his sentencing proceeding. Given the jury's clear verdict acquitting Mr. Combs of the RICO conspiracy, this is from the defense, of the RICO conspiracy and sex trafficking counts, continued detention of Mr. Combs is inappropriate. As these proceedings have demonstrated, and as we told the court from the outset of this case, Mr. Combs came to New York to surrender in order to defend against the government's charges because he was committed to showing his innocence. Docket 13 at 1. Since his arrest and detention on September 17th, 2024, Mr. Combs has obeyed the court, respected these proceedings, and demonstrated model behavior at the MDC. And today, the jury unambiguously rejected the government's allegations that Mr. Combs ran a years-long criminal enterprise or engaged in sex trafficking. The core of the government's case. Mr. Combs stands convicted of 2 Mann Act accounts, and his sentencing exposure is substantially lower. And when the government initially, than when the government initially sought detention, the court should release Mr. Combs on the proposed conditions. So they said they put the applicable law saying that a defendant who has been found guilty of an offense is entitled to release pending sentencing if the court finds by clear and convincing evidence that he is not likely to flee or pose a danger to the safety of any other person or the community if released. Okay, and then aside from the burden of proof resting on the defendant rather than the government, the operative standards are the same as those outlined in section 3142B or C, that the court considered at the outset of the proceedings. So it says thus, when evaluating whether the defense has met its burden, the court must consider if a condition or a combination of conditions will reasonably assure the appearance that the person as required and the safety of any person and the community. As for flight risk, it is insufficient to rely only on evidence of the commission of a serious crime and the fact of a potentially long sentence to support a finding of risk of flight. Rather, the court must sensitively consider several factors, including the length of prison time the defendant faces and his individual circumstances, whether familial and community ties will make flight unlikely, his actual ability to flee and evade the law, evidenced by such things as whether he has a passport, familiarity with other countries or locations, or the financial ability to do so, and the incentive to remain provided by the anticipated harm that will befall any sureties. Moreover, a defendant's past history of compliance with release conditions and court attendance are highly relevant. Regarding the dangerousness prong, there are two components. First, the question is whether the defendant poses a safety risk to any particular individuals, any other person. Second, as to the safety of the community, the question is whether the defendant is likely to criminally recidivate, commit future crimes against the community as a whole. The question appears to become one of propensity. Hold on a minute, my thing just... Hold on a second. Okay. Propensity to commit further crimes. Okay, and then it says, during the initial bail proceedings, the government argued that Mr. Combs was a flight risk because he was charged with serious offenses, carrying significant, in some cases, mandatory terms of imprisonment. The circumstances are now the opposite. The base offense level for a violation of the Mann Act is 14. Because there are 2 counts of conviction relating to 2 separate victims, Section 3D1.2 instructs that the counts are grouped separately. Because the offense level for each group... Oh my gosh, this stupid thing. I keep getting a pop-up thing on here. Okay, for each group is 14, and additional 2 levels are added, resulting in a total offense level of 16. Mr. Combs is in a criminal history category 1. This results in an expected guidelines range of 21 to 27 months. Wow. Mr. Combs has already been incarcerated for 10 months. His sentencing exposure, which we fully respect and do not seek to minimize in any way, is in fact low, and so in any corresponding risk of flight. So is any corresponding risk of flight. Mr. Combs' actions prior to his arrest in 2024 further demonstrate that he is neither a flight risk nor a danger to the community. Mr. Combs knew he was under investigation and likely to be charged early in the year, but he was not arrested until September of 2024. So wait a minute, they're saying 12, 10... they're lying about, he's been incarcerated for 8 months. It hasn't even been 9 months yet until July 17th, correct? They're shaving some stuff off there, right? Okay. No, it's 9 months, and they're saying 10 months. Okay. He's likely to be charged early in the year. He was not arrested until 2024. In the intervening months, he demonstrated that he is trustworthy and committed to respecting the legal process. When it became apparent to counsel that Mr. Combs would be formally charged, Mr. Combs did something extraordinary. He left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. What a guy. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York. offered to tell them specifically where he was and offered to turn himself in at the appropriate time. The government rejected that offer and elected to arrest him, but Mr. Combs' own conduct was the opposite of flight. He affirmatively and proactively sought to cooperate with the legal process. Even before his offer of self-surrender, Mr. Combs demonstrated a pattern of trustworthiness and cooperation. Mr. Combs's residences were searched in March of 2024, and even before that, Mr. Combs and his counsel were aware that the United States Attorney was investigating him for serious crimes. Throughout this time, Mr. Combs acted forthrightly and remained committed to the process. First, shortly after the searches on April 1st of 2024, counsel took possession of Mr. Combs' U.S. passport. On the same day, his counsel advised the prosecutors that Mr. Combs had surrendered his passport. The defense counsel would not return it to him, and that he could not leave the country. The passport remains in defense counsel's possession. Second, counsel advised the government that if Mr. Combs intended to travel domestically, counsel would so inform the AUSAs. All subsequent travel was done with the government's knowledge. Third, Mr. Combs voluntarily relocated to New York on September 5th of 2024. Once Mr. Combs arrived in New York, defense counsel immediately informed the government of Mr. Combs' whereabouts. Fourth, he paid off the mortgage at his residence at 2 West Star Island in Miami. The payment of about $18 million was for one reason alone. So he would have this $48 million residence free and clear of any encumbrances so that it could be used to secure a bond. All this shows that Mr. Combs is not a flight risk. To the contrary, he has taken extraordinary measures demonstrating that what he always wanted was to cooperate with the legal process so that he could establish his innocence in this court. That is precisely what he did as to the most serious charges against him. Moreover, as for other factors the court must consider, such as familial and community ties, the court need only consider Mr. Combs's and his family's conduct over the last 10 months and prior to assure itself that there is simply no risk Mr. Combs will seek to flee or recidivate. Throughout these proceedings, Mr. Combs's family has been seated by his side, demonstrating the same respect for these proceedings and support for Mr. Combs that they will pay going forward. They were here and are here to support him, and he is obviously committed to reuniting with this family to continue to support them, not to flee or put them at further risk. As just a few examples of what Mr. Combs has missed since he has been incarcerated, he has missed the biggest moments in his daughter's life. He missed his twins' high school graduation. They did not have any parent there with them because of their mother, Kim Porter's tragically passing away in 2018. He missed his twins' prom. He has a minor daughter, 2.5 years old, who has been without him for 9 months. He needs and wants to be with and remain with his family. At today's hearing, the government suggested that Mr. Combs could still be a danger in the sense that he still had the means and ability to commit prostitution crimes. With all due respect, that suggestion is unsupported. The government had, for an extended period of time, a pen register on his phone. Mr. Combs never called any potential escorts or prostitutes, nor did he make any effort to arrange meetings with escorts or prostitutes, nor was he with Jane in New York. In any event, reasonable conditions would ensure that Mr. Combs would not have the ability to arrange meetings with escorts. Cases overwhelmingly support release under the circumstances. And then they cite some cases here. Okay, we're not going to go into all that. And the case as it stands, simply not in the same category of other cases where detention for a Mann Act defendant was deemed appropriate. And then puts another case there. Let's see here. The defense proposes the following bail package. Let's see what they're proposing, okay? my gosh, my thing just jumped again. Hang on, it keeps jumping to the prosecution. A $1 million bond, co-signed by Sean Combs, his mother, his sister, and the mother of his oldest daughter. It's crazy, isn't the mother of his oldest daughter? Mr. Combs' travel will be restricted to the Southern District of Florida, Central District of California, and the Southern District of New York to attend court and meet with his counsel, as well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. I guess he's going into Newark. Okay. Mr. Combs' passport surrendered to pretrial services, drug testing, as ordered by pretrial services, all other standard conditions of pretrial supervision. For the foregoing reasons, the court should release Mr. Combs on the proposed conditions. Okay, so that's the defense. Now let's see what the prosecution is saying. All right, I just want to, let me just make sure that we're live here. Okay. All right. Hi, Rosalita. All right, let me go back. I just wanted to make sure that our feed was still going. Okay, so here's what the prosecution said. Dear Judge Submaranian, the government respectfully submits this letter following the jury trial of the defendant, Sean Combs. Following a 7-week jury trial, the defendant was found guilty of 2 counts of interstate transportation for the purpose of prostitution in violation of 18 U.S.C. 242(1)(a). The defendant has moved for bail pending sentencing under the Bail Reform Act. However, because detention is mandatory under the Bail Reform Act, 18 U.S.C. 343(a)(2), he is not entitled to release, and his detention must be continued. Over the course of 7 weeks, the jury heard evidence of the defendant's violence, interstate transportation of numerous individuals for prostitution, drug use, and distribution, and attempts to escape law enforcement detection. This conduct spanned 2 decades. At trial, the defendant did not walk away from these facts. Indeed, the defendant embraced the fact that he was a habitual drug user who regularly engaged in domestic abuse. Rather, the defendant argued that despite his repeated violence against girlfriends, he did not engage in sex trafficking, and despite his prolific drug use, he did not engage in racketeering activity. The jury subsequently acquitted the defendant on counts related to racketeering conspiracy and sex trafficking. The defendant was convicted of 2 counts of violating the Mann Act by transporting girlfriends and male commercial sex workers interstate for the purpose of engaging in acts of prostitution. Specifically, the defendant caused these individuals to travel interstate and internationally for the purpose of engaging in freak-offs or hotel nights, elaborate, multi-day sex performances involving significant drug use that the defendant directed, pleasured himself during, and often filmed. The evidence presented over the course of 7 weeks showed that the defendant did this repeatedly, including after the defendant undisputably knew that he was under federal investigation. Additionally, the facts adduced at trial show, among other things, that the defendant serially abused a former girlfriend, Cassandra Ventura, and that Ms. Ventura sustained injuries from many of these assaults. One such assault that took place in March of 2016 was captured on surveillance video. This video, a version of which was published by CNN in May of 2024, showed the defendant throwing Ms. Ventura to the ground, kicking her repeatedly, and attempting to drag her down the hallway. This was far from the only assault the defendant perpetrated on Ms. Ventura. Trial testimony from multiple witnesses recounted numerous other instances of abuse in which the defendant slapped, hit, kicked, and dragged Ms. Ventura by her hair. Despite the defendant's claim in a public social media post that he was a changed man following the leak of the surveillance video, the defendant continued to engage in violent conduct. In June of 2024, the defendant choked, kicked, and punched another girlfriend, Jane, and then directed her to take drugs and to perform in a freak-off. This incident occurred months after the defendant's residences were searched by federal agents, when the defendant unquestionably understood that he was under federal investigation for sex trafficking by force, fraud, or coercion. The facts at trial also showed that the defendant regularly bought and consumed drugs, including drugs that he provided to Ms. Ventura and Jane during freak-offs or hotel nights. In addition to the June 2024 violent incident involving Jane, the defendant also engaged in other criminal conduct while he was aware that he was under federal investigation. During the March 2024 searches of the defendant's residences, law enforcement recovered narcotics and 3 separate firearms with defaced serial numbers. Further evidence at trial established that the defendant engaged in transportation for purposes of prostitution with Jane as recently as August of 2024, a mere month before his arrest, where Jane had sex with an escort in front of the defendant at the defendant's 2-Star Island residence. Indeed, the defendant was planning to fly Jane to New York for that same purpose in September of 2024, mere days before his arrest. In September 2024, at the time of his arrest in Manhattan, law enforcement recovered $9,000 cash and drugs, including MDMA and ketamine, from the defendant's hotel room. The guidelines calculation in the case is complicated, and the government expects that it will be litigated by the parties. For the purposes of this detention hearing, the government sets forth the below preliminary calculation, subject to revision, which the government believes is the minimum guidelines calculation applicable to this case. The guideline applicable to count 3 is USSG 2G1.1 pursuant to USSG 2G1.1. The base offense level is 14. The guideline applicable to count 5 is USSG. The baseline offense is 14. Grouping analysis pursuant to USSG, again, because the offense involved more than one victim, Chapter 3, Part D is applied. As if the promoting of a commercial sex act or prohibited sexual conduct in respect to each victim had been contained in a separate count of conviction. Because there are more than 6 victims, and each victim, as if they had been contained separate counts of convictions, there are more than 5 groups. Each group has an offense level of 14. Even setting aside Ms. Ventura and Jane, the evidence at trial showed that the defendant transported 7 escorts: Jules, Theodore, Clayton, Howard, Julian, Sapp, Cabral, Williams, Paul Arthur, Michael, Ejiyawoko, a.k.a. Reggie, and Rico Bozant. Okay, hold on a minute, because let me do that again, because I thought those were separate names. Jules Theodore, 1 person. Clayton Howard, 2. Julian Sapp, 3. Cabral Williams, 4. Paul Arthur, 5. Michael Ejiyawoko, 6. Also known as Reggie, and Rico Bozant, for the purposes of promoting commercial sex acts. Accordingly, under the section USSG 2G1.1D, there are more than 6 victims. Okay. A victim means a person transported, persuaded, induced, enticed, or coerced to engage in or travel for the purposes of engaging in a commercial sex act or prohibited sexual conduct, whether or not the person consented to it. Okay. In calculating the combined offense level pursuant to USSG 3D 1.4, Because the 5 groups are equally serious, the offense level is 19. Chapter 3, enhancements. Pursuant to USSG 3B1.1, because the defendant was a manager or supervisor and the criminal activity was otherwise extensive, 3 levels are added. The evidence at trial showed that the defendant was a manager or supervisor of one or more other participants, namely Ms. Ventura and Jane. Further, the criminal activity was otherwise extensive. When considering whether criminal activity was otherwise extensive, Application Note 3 instructs the court to consider all persons involved during the course of the entire offense. As an example of criminal activity that could be otherwise extensive, the application describes a fraud that involved only 3 participants but used the unknowing services of many outsiders. Here, the evidence at trial demonstrated that the defendant used the services of many of his employees, including his chief of staff, Christina Coram, his travel advisor, his security staff, and his assistants in order to carry out the offenses of conviction. Even if all of these employees were unknowing participants, their years-long assistance in facilitating the criminal activity satisfies the criteria for this enhancement. Pursuant to USSG 3C 1.1, because the defendant willfully obstructed or impeded or attempted to obstruct or impede the administration of justice with respect to the investigation and prosecution of counts 3 and 5, and the obstructive conduct related to those counts and relevant conduct, 2 levels are added. He's leveling up. The defendant attempted to obstruct justice with regards to counts 3 and 5, those are the ones he was found guilty on, in multiple respects, including his attempts to pay off security guards following the assault of Ms. Ventura at the Intercontinental Hotel in Los Angeles, California, and in his calls to Jane following the settlement of Ms. Ventura's lawsuit. With regard to the Intercontinental Hotel assault, Application Note 1 provides that obstruction conduct that occurred prior to the start of the investigation of the instant offense of conviction may be covered by the guideline if the conduct was purposefully calculated and likely to thwart the investigation of the prosecution of the offense of conviction. The evidence at trial showed that in the minutes following his assault on Ms. Ventura, the defendant offered Israel Flores a stack of cash and attempted to shut Mr. Flores out of the hotel room where Jules Theodore, an escort, whom the defendant had previously transported for the purpose of engaging in prostitution, was hiding his offense. In addition, at the testimony of Eddie Garcia revealed in the following days, the defendant took further steps to pay off security staff to secure a video of his crimes, preventing further law enforcement investigation. With regard to the defendant's recorded calls to Jane in November of 2024, the defendant attempted to feed Jane a false narrative regarding her participation in hotel nights to silence Jane and prevent the law enforcement investigation into the conduct, which encompasses the conduct underlying counts 3 and 5 that gave rise to this case. Accordingly, the total offense level for counts 3 and 5 is 24. Criminal history category. Based upon this office's current understanding, including through representations by the defense has 0 criminal history points. In accordance with the above, the defendant's criminal history is category 1-3, sentencing range. Accordingly, based only on preliminary calculations set forth above, the defendant's guidelines range in at least 51 to 63 months imprisonment. The government notes, however, that the guidelines applicable at sentencing may be higher than this preliminary calculation. The government had not adequate time to carefully consider all potential applicable guideline provisions. For example, as the court is aware, evidence presented at trial in support of the defendant's convictions on counts 3 and 5 overlaps substantially with evidence related to the sex trafficking counts. Accordingly, much of the conduct is not included in the guidelines definition of acquitted conduct and may be relevant to the guidelines calculation. For instance, the government expects to seek the application of the 4-point enhancement pursuant to the 2G1.1b, 1b, 1i for offenses involving fraud or coercion. Coercion includes any form of conduct that negates the voluntariness of a victim. The government requires additional time to consider any other potential enhancements or cross-references that may be applicable. Applicable law is the Bail Reform Act, and it governs whether a recently convicted defendant is eligible for release pending sentencing. Specifically, where a defendant has been convicted of a crime of violence and is awaiting sentencing, as the defendant is here, the defendant should be detained unless the judicial officer finds there is a substantial likelihood that a motion for acquittal or a new trial will be granted. An attorney for the government has recommended that no sentence of imprisonment be imposed on the person, and the judicial office finds by clear and convincing evidence that the person is not likely to flee or pose a danger to any other person or the community. The defendant must fulfill both prongs of the standard set out in the subsection B, i.e., the defendant must demonstrate by clear and convincing evidence that he is not likely to flee and not be a danger to society or any person or the community. Clear and convincing evidence is that which produces in the mind of the tier of fact a firm belief or conviction as to the truth of the allegation sought to be established, evidence so clear, direct, and weighty and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. Absent government recommendation that no sentence of imprisonment be imposed, these criteria are nearly impossible to meet. The Bail Reform Act permits a limited safety valve from mandatory detention under 18 U.S.C. 3145C. A defendant subject to detention pursuant to Section 3143A2 may be ordered released under appropriate conditions if two requirements are met. First, the district court must find by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. Second, it must be clearly shown that there are exceptional reasons why such person's determination would not be appropriate. Detention would not be appropriate. Exceptional circumstances exist where there is a unique combination of circumstances giving rise to situations that are out of the ordinary. Collecting cases and noting that circumstances that are purely personal do not typically rise to the level of exceptional, warranting release. The defendant must be detained pursuant to the Bail Reform Act as detailed above. The offenses of conviction constitute crimes of violence and mandate detention following the defendant's conviction. Here the defendant has been convicted of two such crimes. Because of the near impossibility of meeting the stringent criteria set out in Section 3143A2AB, the only conceivable basis for release here is the existence of exceptional circumstances. However, as the Second Circuit has recognized, the exception is very narrow exception. Indeed, the circuit has revised a district court's decision to release a defendant on bail pending sentencing of this basis. This district court's decision to release the defendant on bail pending sentencing, finding that even assuming that the court reasonably concluded that Leah, hold on, I'm not going to go into the citing of the other stuff. Since exceptional circumstances exist where there is a unique combination of circumstances giving rise to situations that are out of the ordinary, there is nothing exceptional about going to school, being employed, or being a first-time offender, either separately or in combination. The defendant utterly fails to show exceptional circumstances here. As detention is mandatory following a conviction of a Mann Act offense, the government has been unable to locate a case in which a defendant was released from custody following such a conviction. Indeed, the government has only identified several cases where the defendant was detained pretrial and remained detained through sentencing. And it lists those cases. Okay, let me get to where Okay, section 924C, counts, Mann Act counts, was acquitted, let me see. Here there is yet heightened burden that the defendant must carry now that he has been convicted of 2 felony Mann Act offenses because of his mandatory detention. Even if detention was not mandatory here, which it is, the defendant cannot meet his burden to show by clear and convincing evidence that he is not likely to flee or pose a danger to any other person or the community. First, given the significant potential penalties, the defendant continues to be a flight risk. As described in Section 2 above, at minimum, the defendant faces a guideline range of 51 to 63 months imprisonment, and the guideline range found at sentencing may be higher. The possibility of a substantial sentence such as this is a significant factor in assessing the risk of flight. Let's see. The defendant has now been sentenced. Oh no, that's still citing a case. Hold on. I don't want to get into all of these other cases. We'll be here forever. Okay, so the heightened burden of proof placed on the defendant to establish that he is not likely to flee by clear and convincing evidence, particularly given the not unreasonable presumption that the defendant concealed his criminal activities from his family in the past. Second, the defendant cannot meet his burden to demonstrate by clear and convincing evidence that he is not a danger to the community. The overwhelming evidence established at trial, which the defendant did not dispute, shows the defendant has engaged in a year-long pattern of abuse and violence, including as recently as June 2024, approximately 3 months before his arrest in this case. Despite the knowledge that he was under federal investigation, the defendant nevertheless brutally assaulted Jane, leaving injuries that were visible for days after the assault. Additionally, when the defendant traveled to New York City, where, according to the defense counsel, the defendant was waiting to be arrested in this case, he was in possession of drugs and the materials necessary for a freak-off. The defendant's conduct after he understood that he was under federal investigation underscores that he continues to be a danger to others and is either unable or unwilling to follow the law. The government respectfully submits that given the jury verdicts on counts 3 and 5, the likelihood that a motion for acquittal will be granted is quite low. Additionally, as discussed above, the government will not recommend that no sentence of imprisonment be imposed. At least one trial witness who was a victim of the defendant's violence vehemently opposes the defendant's release pending sentencing due to the serious and immediate threat to victims, witnesses, and the broader community. For the reasons set forth, the defendant's continued detention is required under the Bail Reform Act. Accordingly, the defendant's application for bail pending sentencing should be denied. Okay, so that was signed Jay Clayton, United States Attorney. So let me see what is the latest. Cassie Ventura's lawyers want the judge to deny bail. The judge sets a 5 p.m. Wednesday bail hearing for Sean Combs. So 5 p.m., they're going to have a bail hearing. The prosecutors argued against bail, citing those crimes of violence. And the defense lawyers argue for Sean Combs to be released on bail. And I just read to you both the proposals from the defense and the prosecution regarding the bond, for him being released on bond. One federal sentencing expert predicts a relatively short prison term. There's an unusual crowd that has grown outside the courthouse in Lower Manhattan. Okay, so let me see what you guys are doing. Thank you for sitting through that. Thanks for this, Carolyn. I have to go. Oh, you're going? Okay. All right. Hi, Rosalita. Thank you, Murder of Crows. Thank you again for your super chat. Hi, cute kitty kitty. How are you? The jury blamed victims because they were taking it, says Gianna. Gianna says disgusting. Diddy is a nut, Gianna says. Hi, Denise. Have a good rest of your day. Rochelle's going. Okay. Captain Lee is agreeing with Rosalita. Rosalita says Bucky Ann's creation. Yes, I totally agree. Why should they be able to pass time with the internet, TV, and phone calls? Why give inhumane people privileges? Dragon Girl says, I think the prosecution just read that off. Let's see. Christine said, I can't understand how the parents are okay. Okay, I think. Okay, that's on Kohberger. Okay, you guys are talking about Kohberger over there. Good to see you always, my Marie. It's good to see you, cute kitty kitty. And so 5 o'clock bail hearing. It is 2:51. Can I take a poll before we go? Let's take a poll. All right, let's see. And see if you're right or not, okay? Do you think Sean Combs will be released on bond today? Okay, let's see. So take a moment. Let's see. And then after we take a moment with the poll, we will go. Now 100% are saying yes. I don't know where I'm falling in this. I think, you know, the prosecution made good points. You have Cassie Ventura, a victim here, saying that she opposes his release. Now, it's very possible, and I don't know, but she has 3 young children. She could be stating that she doesn't feel safe and she wants to get security and get away from him and doesn't feel she'll have ample time if he's released at 5 o'clock or if he knows where she is, given past history. I would be very, it's reasonable for these people to be scared. But in all actuality, with the amount of family members, his sons, and everything at his disposal, he could easily do harm to any of them because he is usually, it was not him that put the Molotov, threw the Molotov, what do they call it, that cocktail in Kid Cudi's car, right? But he went to Kid Cudi's. So he has other people do this stuff, which he potentially could have these people do this even if he's incarcerated. So he's a dangerous guy, right? He's a dangerous guy. He is. There's no doubt about it. Many people believe he's behind what happened to Tupac. So, I don't know. I don't know. But the way it's going, I'm going to say, yeah, I'm going to say he's going to walk out today. Just the way things are going, okay? I don't know. It's a sad thing. But when you have money to this extent, right, that you're just paying off a mortgage with $18 million, money does talk. Money talks. So, Diddy's probably going to walk. And he's probably going to get a relatively short prison sentence. And, again, the way things are going, he could get off on time served and probation. So we'll see. We'll see. But anyway, he could afford the best, the as in the dream team, right? The dream team of defense lawyers. And money talks. Murder of Crows said he won't serve any time. I'm starting to feel that way too, Murder of Crows. Yep. Definitely feeling that way. And again, in case you just joined us, you can go back. We have the Kohberger change of plea hearing in its entirety. And Bryan Kohberger did enter the guilty plea for the burglary and for the murder of all 4 individuals, Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Xana Kernuttel. And the prosecution then gave an overview of the evidence they had that they would present at trial. They said the gag order will remain in effect until the sentencing, at least. They did not mention the release of discovery after the sentencing, which I hope they do. And there was, it looked like he was wearing a bulletproof vest. It is the last time that he'll wear civilian clothing. He is a convicted man now. He pled guilty. He is no longer presumed innocent. He is guilty of his crimes. And he will wear his jail clothing for his sentencing, which is July 23rd into July 24th if they need the time due to the amount of victims' impact statements. So, that, you're still listening? Okay. That's what we have in a nutshell in this video. Thank you so much for watching. Thank you so much for watching on the replay. And we appreciate each and every one of you. Now, before we go, I do want to do one other legal thing. I did mention at the start of this broadcast that I updated the GoFundMe legal page where it has the updates. And I'd like to read to you the latest update on that, okay? If you want to see it for yourself, you can go to the GoFundMe, and you can get there through the community post. There's a link, but I'd like to read it to you, okay? So it says, our trial is scheduled to begin on Monday, July 7th, at the White Plains Federal Court in New York. It starts at 10 a.m. Eastern Standard Time, with the Honorable Judge Kenneth Krass presiding. Excuse me, oh my gosh, I can't speak today. Judge Kenneth Karras presiding. My eyes, I'm going to go to the eye doctor because my eyes are really, my contacts are getting, I probably should get some drops. They're getting dry and they're bothering me. Okay. Judge Karras. The other side is blasting and boasting that the Honorable Kenneth Karras is biased in their favor. Those with a level head know how insulting that implication is to a federal judge. A federal judge is expected to be impartial and look at the facts of a case. The other side allegedly thinks this case is a joke. They have spoken on multi-hour live streams, played songs, and written comments stating the judge presiding over this case is biased in their favor. They have tried to taunt and intimidate me by saying that I am going to trial with a judge who is biased in their favor. In their blatant mockery of the judge and federal court, they played a song whose lyrics told a story of this judge, trial, and ruling in their favor, and insulting myself, my attorney, they called an ambulance chaser among other things, and the judicial system itself. What a mockery they are making of the federal court, the honorable judge, and all who have donated money to them. This is a federal court, not a circus, but that is exactly how they are treating it. It is deplorable. We have saved all their live streams, comments, and videos that mention this bias because, you know, they'll delete it. You know. I don't know of any judge, federal or otherwise, who would think this is funny or harmless. Now, as if, I don't know, a gift, this judge in the Kohberger case addressed calls to the Ada County Courthouse trying to influence his decision on to reject the plea deal and stuff. And he said that you can't do this. Not only does this take the court's resources, but to imply that phone calls or otherwise are going to influence him. It's wrong. Can't do that. So all of this mockery and this stuff that's happening on social media, judges don't like this. But to blatantly insult them, a judge's whole character, everything is to be impartial, to not let emotion get into this, but to look at the facts. And so for someone to imply that he's biased, that he's already decided the case, that my attorney is an ambulance chaser, that we're being laughed out of court and the judge has taken his gavel. You should listen to this crazy song. That is insulting to a federal judge, because what it's basically saying is a federal judge is not performing as a federal judge. You think a federal judge thinks that's funny or a joke? And otherwise, what does that say to anything about what this case is to them? A joke, a mockery? Is this truly about copyright? Okay, so I go on to say, we are confident in the facts, and we know that a federal court judge will be concerned with the facts and only the facts. This is a copyright case. Heather Schaefer is alleging I did not consider fair use when I issued the DMCA takedowns because Heather Schaefer took my original exclusive content without my permission and uploaded it on Held to the Nose YouTube channel. I know and have shown through my prior knowledge of fair use and my submitted evidence of web browser searches and URL data for pages relating to copyright and fair use that I considered fair use. They are lying to everybody and saying that I submitted no proof of anything. I voluntarily gave my web browser history that showed where I was on pages relating to fair use and had prior knowledge, as was shown via the deposition. Beyond that, I verified that I considered fair use by stating that under penalty of perjury on the DMCA form itself, I am well versed on the 4 components or principles of fair use. But most people know that fair use is a gray area and that the 512 copyright law itself protects copyright holders if they unknowingly made a mistake in deciding if something constitutes fair use. Given all that, we are confidently heading to trial. There are things we cannot comment or talk about now, but trust me, when all is over, I will be able to fill you in on other things. From the bottom of my heart, my family's hearts, we thank you for your continued support in this case. We could never have done this without your prayers, love, and financial support. You all mean so much to us. Keep those prayers coming. We are in the home stretch. If you can donate, we thank you. If you can share this fund out, we thank you. And we ask for your prayers. We are putting our faith in God and know He sees the truth and will bring us the justice we are seeking. In Jesus' name, amen. And again, thank you to you all. Thank you to everyone that supported me in every single way. Through emails, through messages, through donations, through sharing the fund, through just being there to listen, in every way. Thank you. And on that, I have a call. Hold on one moment.